We have major breaking news out of the United States Court of Appeals for the Fifth Circuit down there in Louisiana and Texas. The Fifth Circuit in a 3-judge panel has ruled unanimously that the expanded background checks for 18, 19, and 20-year-olds under the Bipartisan Safer Communities Act, which is the Joe Biden, John Cornyn debacle, gun control law from 2022. The 3-judge panel said that the expanded background checks applied to 18, 19, and 20-year-olds are not unconstitutional and do not violate the Second Amendment. They based this decision on the dicta of the U.S. Supreme Court in Nysurpa versus Bruin. Let's break down this 3-0 loss against the Second Amendment out of the U.S. Court of Appeals for the Fifth Circuit when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many gun and Second Amendment related books, including Disarm What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, I'm in a suit today because I had Fox News. That's going to be an ongoing appearance, or an ongoing event, I should say, through the end of the year. So, just get used to me in a suit more than I usually am. I try to avoid this, but sometimes I have no choice. All right, so unfortunately, the United States Court of Appeals for the Fifth Circuit has just ruled in a 3-0 panel decision by some pretty good judges, by the way. These are not anti-gun liberal judges or anything. That based on the Supreme Court precedent of Nysurpa versus Bruin and even Heller, the expanded background checks applicable to 18, 19, and 20-year-olds and the slight delay, as they frame it, of up to 10 days is not violative of the Second Amendment. This is consistent with the Second Amendment. According to Judge Jerry Smith's ruling, Judge Smith is a very good judge. So again, he's not like an anti-gun guy, but he basically, having analyzed Bruin and Heller's language, seems to be indicating that, given the fact that they seem to have signed off on two general things, and by I mean the U.S. Supreme Court has signed off on the notion that background checks associated with permitting regimes are okay. They quote the language out of Nysurpa versus Bruin that says that the licensing arrangements associated with shall issue permitting regimes to make sure that only law-abiding citizens have access to firearms, that is generally applicable and generally lawful under the Second Amendment, with the asterisk that says that if those licensing regimes are abusive or take too much money or take too much time, they might violate the Second Amendment. But the argument here, according to Judge Smith, was there's no evidence here that the background check from what normally occurs with a normal American citizen, expanding it up to 10 days for 18 to 20-year-olds, that did not appear to violate the text of the Second Amendment, especially based on the Supreme Court's dicta in Heller and in Bruin. So as you may recall, the court in this McRory versus Garland case, and that's the name of the case, McRory versus Garland, I'll put a link to the decision down below, goes through the process of what a NICS system is, the background check system is, and how it came about and what it means. Then they go on specifically to say that in addition to what normal American adults go through, there's now additional information, additional background checks if you're 18, 19, and 20 years of age. The concept, of course, was that there were juvenile records out there that were sort of being hidden and hard to find. So 18, 19, and 20-year-olds that engaged in violent conduct before they turned 18, they were getting firearms and so on, and that could have been technically a violation of 18 U.S.C. 922G because they might have been prohibited people. Nevertheless, this is what Judge Smith writes. Specifically, he says, as relevant here under the 2022 Act, as you may recall, this is the act that was enacted and signed into law by Joe Biden. This is the John Cornyn special, where he decided on the eve of our major Second Amendment win in Nysurpa versus Bruin, John Cornyn and some other Republicans decided to team up and give the Democrats a win on gun control because our Republican Party in many instances are not very smart, unfortunately, and John Cornyn is definitely one of the worst of the worst. Hopefully people in Texas know what to do with him when the time comes at the next election for the U.S. Senate seat of John Cornyn. But let's move on. Specifically, what Judge Smith says is under federal law, the NICS system, the NICS system, must immediately contact 3 additional entities beyond NICS, specifically looking for the criminal history repository or juvenile justice information system of a particular state. They should also contact the appropriate state custodian of mental health adjudication records to see if that person was in there, and also local law enforcement of where the person resides. Now, if this doesn't occur in a time period of up to 10 days comes and goes, then the 18, 19, or 20-year-old is allowed to acquire that firearm. Just as a reminder, under federal law, FFLs are not allowed to sell to 18, 19, or 20-year-olds handguns, which is being challenged right now in the Reese case down there in the U.S. Court of Appeals for the Fifth Circuit, and I think we will win that case. But in terms of this McCrory case, we lost this basically because they said that the Supreme Court has indicated repeatedly that basic commercial transaction rules don't violate the Second Amendment based on language they used out of the Heller case, and then the language out of Bruin that says that shall issue permitting regimes that allow for a background check are also generally fine. So here is what I'm not super happy about. I wonder whether or not this case should have been brought, because the upside, now there's no Second Amendment violation, there's no gun control law as a general matter I support, including this one. With that said, sometimes you have to be strategic about which lawsuits you bring, where and when. And given the fact that there's a lot of other major Second Amendment cases out there that are taking up the court system's time, you have to sort of pick and choose a little bit. And as much as I would support the notion of 18, 19, and 20-year-olds having the exact same background check rights as any other American and not be subjected to further scrutiny beyond what other Americans have to receive or undergo scrutiny for, the reality is that I'm just not sure that the upside of winning this case was big enough, given the dramatic chance of losing and the very high likelihood chance of losing, given two things: the dicta in Heller and Bruin on the one hand, on the other hand, the fact that the U.S. Supreme Court is probably not going to get to the 18, 19, and 20-year-old issue, at least in terms of the background check issue, for many, many years. So why push the issue now? I might have sat back and waited on that, because keep in mind, there were 2 plaintiffs here, 2 individual plaintiffs. There was Ethan McCrory, age 20, and Kaylee Flores, age 19. In May, and you'll see why I don't love this fact pattern. In May of 2023, they both attempted to purchase shotguns from FFLs in Texas. Fine. They were informed that their purchases were being delayed because of NICS protocols. Yes, annoying but understandable. That's the way it works. Then it said, but here's the key. Instead of waiting up to 10 business days, McCrory and Flores sued that same day, requesting a preliminary injunction. Okay, fine. Here's the issue, though. See, this is the potential problem. McCrory's purchase was approved 5 days later. 5 days later. And then Flores' purchase was allowed to proceed by virtue of hitting the 10 business day cap on May 27th. So and here's the thing, 2.5 months after both individuals could have acquired their shotguns under the challenge law, the district court denied their requested preliminary relief. So it's just not a great fact pattern, because yes, I don't like 5 or 10 day waits at all. I'm opposed to them. But again, strategically, a district court judge is like looking at this case 2.5 months after they could have already acquired their shotgun, and basically saying, well, you have your gun, no harm, no foul, move on. So again, I just think the fact pattern is not strong, because 5 day delay, I don't support 5 or 10 day delays, but on the other hand, given all the other Second Amendment litigation going on right now, the fact that the Supreme Court is overwhelmed with Second Amendment cases, this just doesn't seem to be the kind of high priority situation, in contrast to a lot of the other things they're dealing with that we're going to be able to get a good result on with speed. So again, I probably would have let this one slide, not because I support the law, but because of the unlikelihood of succeeding on this case right here and right now in the current environment. Nevertheless, the case was brought, and now you have this sort of unfortunate precedent in the U.S. Court of Appeals for the Fifth Circuit. Do I think this precedent is terrible? Because what they basically said is that this is not a violation of the Second Amendment, because the Supreme Court in dicta has signed off on these kinds of restrictions when it comes to acquiring or purchasing guns from FFLs. And again, I think it's not a terrible loss here, but I think it was an unnecessary loss. This is what Judge Smith wrote. He wrote, Bruin and Heller make clear that background checks preceding firearm sales are presumptively constitutional. Plaintiffs fail to rebut that presumption. Instead, by reading one passage of Bruin out of context, which I disagree with, but set that issue aside, they ask us to invert it. We decline to do so because that is not a fair reading of Bruin, particularly in light of Heller. Judge Smith seems to hold on to this language from Bruin. He says, quote, "To be clear, nothing in our analysis should be interpreted to suggest the unconstitutionality of the 43 states shall issue licensing regimes under which a general desire for self-defense is sufficient to obtain a permit. Because these licensing regimes do not require applicants to show an atypical need for armed self-defense, they do not necessarily prevent law-abiding responsible citizens from exercising their Second Amendment right to public carry. Rather, it appears that these shall issue regimes, which often require applicants to undergo a background check or pass a firearm safety course, are designed to ensure only that those bearing arms in a jurisdiction are, in fact, law-abiding, responsible citizens. And they likewise appear to contain only narrow, objective, and definite standards guiding licensing officials, rather than requiring the appraiser, or appraiso, I should say, of facts, the exercise of judgment, and the formation of an opinion." So that's what Judge Smith says. He says, in light of that, it seems like a background check is perfectly fine. Now, he does indicate that there may be instances where background checks or licensing procedures could violate the Constitution. This, in fact, is what he indicates in the last paragraph of his opinion. This is what the Fifth Circuit says. In short, there is some point at which a background check becomes so lengthy that it is put towards abusive ends or subject to Bruin's historical framework as a de facto prohibition on possession. But a period of 10 days does not qualify. So again, I'm not thrilled that there's now language in the Court of Appeals precedent that says 10 days as a waiting period is constitutional as a general matter under the Second Amendment, especially coming out of the Fifth Circuit, which is a good Second Amendment court that generally respects the Second Amendment. So I'm not thrilled to have this precedent out there. I don't think it's catastrophic. I think ultimately it will be fine. But again, the Supreme Court has indicated these background checks are okay. I don't see any way to change that in the next few years. So I think we have to be very careful about bringing challenges to licensing regimes unless you're laser focused on excessive delays, excessive costs, and too much discretion or any discretion as opposed to objective standards. I think you got to be careful going forward because you don't want to create unnecessary bad precedent that can be cited against us by the anti-gunners in other cases around the country. Because I can assure you the anti-gunners will cite to this Fifth Circuit case going forward in all sorts of terrible ways and use it against the Second Amendment. You can bet your bottom dollar on that. That's my best guess. Okay? Anyway, folks, hope you learned something here today. I'll put a link to this opinion down below. You can let me know if you disagree with me. Don't forget to follow me on X at @4boxesdiner. Don't forget to subscribe here. We're trying to get to 150,000 subscribers on my YouTube channel, 4 Boxes Diner. And we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.